The third one will be more like an info session. The third one will be more like an info session about the process of international patenting. So what are the steps, how you're gonna have to apply to have the fees taken in charge if you want to apply through the Startup Act advantages. And the fourth one will be like an experience sharing and maybe talk about improvement areas of the process. The idea of the second of this training is, so I'm gonna let Alfred take the lead, but I just wanted to let you know that since you're not a lot of people, so we won't have a Q&A session at the end, so feel free to ask your question during the training. Aya and I will facilitate the training, and Alfred Zeher and his team will lead the training. Also, before presenting the expert, the speaker that will, before that, I suggest maybe, Alfred, that we do a roundtable of the attendees, and maybe if they can explain a little bit, like in two phrases, like what they are doing and what they are expecting from this training. Or maybe you want to present the speaker first. It's up to you, Alfred.
Thank you, Aya. Again, it's a great pleasure to be able to speak with you today. My name is Alfred Zeher. With me are my colleagues from my firm. Sean Lee. Dr. Lee is a biotechnologist, patent lawyer, very experienced. We've all worked together for many, many years. Following him is Richard Moss. Richard and I have worked together for almost 20 plus years. Dr. Farley, Patrick Farley, is also a biotechnologist. Richard has a degree in electrical engineering. We have Yi Lu, who is a mechanical engineer, a licensed Chinese patent lawyer, and a US lawyer. And we have Matteo Bunuzzi, who is in our law firm, a very experienced maritime lawyer, but also has worked on numbers of agreements and transactions related to technology. And Matteo is also fluent in French. I think I've covered everyone in our team, and myself, Alfred Zeher. I am the chair of the intellectual property department here at our firm in Montgomery Cracken, and it's a pleasure and joy to meet and talk with all of you. Just a little bit of background. I, myself, and Sean Lee, and several of us here have been doing patent prosecution and trademark prosecution, protecting intellectual property for over 25 years. I personally, and as well as Sean, have been in Tunisia. I've worked with many Tunisian startup companies, many Tunisian companies. My family is Lebanese and Syrian. I've been in the Tunisian and then in Morocco and other North African and Middle Eastern countries for a long, long time. I have many contacts, friends, and still family. My Arabic is Shweya, so you'll have to forgive me for, I am third generation, so I've fallen a little bit of a way. But we all have a common commitment to intellectual property, and I personally have been involved with many important companies, and we'll discuss that as we go through that. I would love to hear from you, and if we can, let me start you off at least in the way that you are on my screen. So Mehdi, would you tell us who you are and what your company is?
Sure. Hello. So my name is Mehdi. I'm the co-founder of a startup called Quali4. Quali4 actually stands for quality and 4 to say 4.0. So as probably everybody knows, industry has moved to the industry 4.0, but quality is still obsolete actually. So what we're trying to do here is we're trying to develop a software solution for quality control management. So quality control is actually applied to various industry, and we are focused on automotive and aeronautical industries to start with. And our aim is to sell our solution for Europe in the first time, and then move on to the US and eventually China.
Okay, very good. Thank you.
You're welcome.
Ahmed? There you are. You're on mute, Ahmed. There you
So
are.
thank you. Yeah, thank you, Alfred, for the presentation of your company. And my name is Ahmed. I'm the CEO and the founder of Moomi. What we do is like the name of the solution we have is we basically develop hardware plus software for to monitor dairy cows. So basically, we are an ad tech startup. We work exclusively in the agriculture sector. The solution why we are here, because the solution is composed of two things, two basic components. The hardware, it's a collar that we have developed with its sensor, with its electronics. And we had a software backend for all of that with our also developed algorithms, AI models. So this is basically what we do.
And your trademark is Moo.
Yeah, actually, it's the moo of the cow. And me, like we are saying, hey cow, tell me what you are feeling. Tell me what you feel. I'm gonna help you.
It's very nice. It's very clear.
Thank you.
Okay, Anis.
Yeah, hello. So I'm Anis Tahbani, CEO of Innova Robotics. We are based in Tunisia and in Paris, and we manufacture security robot. It's like autonomous vehicle for patrolling, reporting, and intrusion detection. So our customer, our security company, and also big area and big plants impact to secure. So the robot system is equipped with the AI algorithms that can detect intrusion, but also abnormal behavior, and can alert the control post command.
Great, thank you very much. Thank you. Let's see, we have Asha. Sorry, Asha. We know who you are.
I don't have a startup, I'm sorry.
No, it's okay. It's okay. Ahmed Hamouda. Ahmed?
Hello, everyone. Actually, I'm part of the Promise project. I'm working on the Activity 2.4, and I used to work on the awareness campaign on Startup Act. So I'm here to gather more information on the how to support startups on IP in both US and China, because I assist them now to obtain the Startup Act label, and it's a way for me to help them or guide them toward you guys and your services. So that's it.
Okay, if you would not all mind, because of the whole COVID problem, we would have been there in person to present to you. So if I could ask you to keep your video on, if you wouldn't mind, it's because it's much better to have an in-person meeting, and it would be more important for us to see each other and to talk to each other. And if you're moving around, it's perfectly fine. There's no problem with that. Everyone is busy. So, but if you would reveal yourselves, I think it'll make a better meeting, and we can see eye contact as we proceed through this. Okay, Asma.
So I'm Ashraf, and I work as an investment analyst at Flat6 Labs. We are an accelerator, but we are also a VC firm. And we have invested so far in 43 Tunisian startups. So one of our portfolio startups is Moomi, which is here actually. Yeah, so we're here so we can learn more about international patenting.
Okay.
with me is there is Asma, who is our investment manager at Flat6 Labs. Yeah.
Can we see you guys? If you don't mind? If possible. If possible.
Of course, just a second.
Sure. Okay. And look at all those wonderful people. Okay. Ahmed, have you spoken Hamuda?
Yes, I just did.
Okay. Okay. Sorry, I didn't see the face, so the blank doesn't connect me. I apologize. Tell me again, Ahmed. What is your technology? Tell me again, if you don't mind.
I'm working with the Promise project, so I'm presenting OST Open Startup Tunisia and the Promise project, and I work on the awareness campaign on Startup Act, and now I'm supporting startups to obtain the Startup Act label. So I'm here more to get more of an idea of what kind of IP and the procedures, how can be implemented.
Got you. Okay. First, let me thank you all for being here. Why don't we let our team explain who they are. Sean, Patrick, why don't you guys do a short explanation? So Sean,
Alfred, I'm sorry, but I think Asma did not present herself. So.
Who has not?
Asma.
Yes, I'm here.
Asma. Yes, Asma, sorry.
I'm present.
Thank you.
No problem.
I apologize.
No.
I called on you, and I guess I'm sorry.
No, there is no problem because I'm part of the accelerator Flat6 Labs, and Ashraf, he did already the introduction.
Yes.
So yeah, we are working on the accelerator. So we are investing in startups. We are not a startup, and we need to have more insights about the international patents.
Great. Well, we really appreciate you're all joining us and coming to this program. Sean, why don't you start us off on us just quickly?
So I'm Sean Lee. I actually grew up in China, and I was studying plant physiology when I was in college. So I know a little bit about plants, and I switched gears to do structural biology in US. And after that, I practiced law, passed the patent exam. So I've been practicing patent law in various capacities for a little over 10 years now. So I'm a partner of Alfred's at Montgomery McCracken.
Thank you, Sean. Patrick.
Good afternoon, everybody. It's a pleasure to be speaking with you today. I'm Patrick Farley. I started my career in molecular biology studying malaria. And then I went to law school and became a patent lawyer more than 20 years ago now. It's hard to believe. And I practiced mostly in patent prosecution, licensing, and helping companies manage their patent portfolios. So and I joined Montgomery McCracken about 6 months ago, but I've been working with Alfred for actually many years. So it's a pleasure to be with Alfred's team again.
Thank you. Rich?
Hi, Richard Moss. My background is electrical engineer. I've been practicing in the intellectual property law space for nearly 30 years. I do all aspects of patent law, patent prosecution, transactional work, litigation. I've had quite a bit of experience in the software area, including representing Deloitte at a prior firm and helping build their patent portfolio as it is. And happy to be here.
Thank you, Rich. Yi?
Hi, my name's Yi. I just joined Montgomery McCracken in March. I have been practicing patent law for 14 years, 12 years in China and 2 years in the United States. It's really nice meeting you.
Thank you, Yi. Matteo, you can do it in French.
D'accord, je vais essayer. Bon après-midi tout le monde, je m'appelle Matteo, je suis originaire de l'Italie, mais j'ai fait partie de mes études en France. Et donc voilà, je suis là pour essayer de connecter dans les cas où vous avez des questions en français et vous n'avez pas... et bon, Alfred et les autres, ils ne vont pas avoir la possibilité de vous répondre en français. Je vais essayer de le faire. Pour le reste, je suis un avocat de contentieux à Montgomery McCracken depuis 2013. Et je fais surtout des contentieux, mais du moment que j'ai eu la possibilité de travailler avec Alfred dans le domaine de la propriété intellectuelle, j'étais ravi de le faire. Je suis très content de vous voir, de vous connaître. Et on va avoir une bonne session, j'espère.
Merci. Yes. Okay. So we're going to proceed through this program, and we're going to go as a little quickly. So I don't want to drain you of all your time this morning or this afternoon. But as you have questions as we proceed, it's going to be the best process. So feel free to just put your hand up or just speak up and ask a question, because it's the easiest way. Now, you all know if you're on mute, if you want to speak, you just push the space bar and your mute comes off. Did you all know that? So if you push the space bar, you can speak and you can stay on mute if you'd like. That way you get the ability to interject. Okay, so we're going to discuss the patent system. We have an outline here that we're going to follow. First, it's going to be an overview of the patenting, the requirements for patentability, which are very, very important. Invention ownership, which are going to be important to all of you as owners. What does it take to get on file? How do we, once we understand the invention, how do we get you on file? That's what it's called. How do we file your patent application, and where do we file? Then we're going to talk about what can be filed, what kinds of inventions. Well, most of you are interested in software, but not all of you. You may have devices that go with your software. You may have processes that are incorporated into what the software makes and produces. So there's lots of things that we can patent, and we're going to explain that to you. And then there's the international filing system, which gives you broader rights in other countries. So we'll proceed with the next slide, please. Here's our overview, the next slide. Okay, this is a picture of me. It was not as flattering as I hope, but the waistline looks much better than mine. So I'm very happy with this picture. So territorially, what does that mean? You get a patent in the country in which you file it. That is the exclusive territorial right of your patent. So if you file for patent in Tunisia, you have Tunisian patent rights, but you have it no place else. If you file it in the US, you have it in the US, but you have it no place else. So your obligation is to file for patent in the countries in which you think you are going to be most productive and successful in. So that means the world has big markets in the US, big markets in Europe, big markets in Asia. So you know you've got three major regions, and you have the Middle East, of course. The populations are smaller, but you still have business to do. So obviously, as a Tunisian company, you're going to want to protect your rights in the places where you're going to think your business is going to be the largest, the most successful. Your patents are limited in the countries you file, as we said, but then you also have a time limit. You get 20 years. You get 20 years from the date of filing. So if you file today, 20 years from today, you'll have patent rights. But your rights will not start until your patent issues. So you could file today. It may take you 3 years, 4 years, 5 years. Some patents can take up to 10 to 15 years to get allowed. Not uncommon. More common in the biopharmaceutical industry, very less common in the mechanical and physical products. Those can take 2 to 5 years. But in pharmaceuticals, sometimes some patents will not issue until their 18th or 19th year. But there are ways to recover that term. You can recover the term if it took a long time to do the prosecution. If there was a lot of activity in the patent office, you can recapture time based in most countries based upon this delay. That won't affect this conversation here today. Next slide, please. Okay. Why should you consider patenting? Well, if you don't have a patent and you have a brilliant invention, you will make no money. You will go nowhere and you will fail. Why? Not everyone. Obviously, that's not true for a lot of companies. So for example, Coca-Cola. Everyone here knows Coca-Cola, don't deny it. Now, what does that mean? Coca-Cola has no patent on their formula, none. They seem to be successful. I would wish to be so successful, and they have 0 patent. So you don't always need a patent to be successful, as that is an example. But in today's technology, when you're doing technology, if your technology can be back engineered or can be copied easily, you have no protection. To this day, no one knows the Coca-Cola formula. That's what makes them so successful, but that's called a trade secret. If you have something so special, so unique, but it cannot be reversed, it cannot be figured out. So for examples, I'll give you, how many of you have been to Paris? I assume many of you. Many of the bridges in Paris and in the UK are built from a cement that was developed in the 1800s. To this day, no one knows how to remake that cement. And that cement has been so impervious to water penetration that's why those bridges are still standing. And to this day, most people don't know how that's made because the inventor died with the formula and never passed it on. Today we have other building methods, but it's important for you to understand there are other things that can give you protections. Okay. What does a patent provide you? It provides you the right to exclude others. So for example, in the Apple-Samsung case, Apple had a simple patent. It was called a design patent that covered the shape. It covered this shape. How many of you have seen this shape before? This shape was covered by a design patent, and it cost Samsung $1 billion to copy it. So patents can be very valuable, but if this was not covered by a patent, that patent cost probably $3,000 or $4,000. And that $3,000 or $4,000 patent earned Apple $1 billion in patent lawsuit. You can't take anything simple for granted, nor something complex, just to give you an understanding of how you can get incredible patent rights. All right, again, it excludes others. And if you don't have one, you risk the right of people copying you. Next slide, please. Okay. Why should you consider patenting? Well, to be honest, most people patent because they want to make money. It is the most typical reason. Very few people file a patent and say, you know, I don't care if I make no money. Let me spend an enormous amount of money getting a patent, and I don't care what happens. I've not met such a client, and nor should there be one. Patenting is a very important thing. It is the basis and the building blocks as to how we have created technology. The point of the patent system is for you to disclose your invention so others can improve it. That's the point. But you get an exclusive period to reward you for doing so. And that's the basis of the patent system. So it enhances your ability to raise money. By filing a patent, investors are going to say, I'm sure many of you have met with investors. The first question is, what is your intellectual property position? Do you have a patent? If you don't, goodbye. Because no one's going to invest millions of dollars in you if you can't have an exclusive concept or device or product that can be protected or exclusive to you for a short period of time. It's like a fashion. If you design a fashion, a dress or a shirt or a jacket, it's highly fashionable, but it will only last a certain period of time because that fashion fades. So you have to be first in the market. You have to have that fashion because someone's going to copy that fashion. That's why it only lasts a year or so. That's why fashions come out every year, because people copy them. In patents, you get a much longer period of time because these are usually much more expensive and costly things. It also gives you access to markets. You're a Tunisian company, you can have access to the US market, to the European market, to the Asian market through your patents. Next slide, please.
Alfred, I saw a question. Somebody
Yes.
had
Please.
had a question about content. So maybe we should chat briefly about what is a patentable invention. And I think the question was, can content be protected by patent? And well, generally content, if you mean works of authorship and things like that, that's the purview of copyright. But if the content is presented through a vehicle, through an inventive vehicle that's protected by a patent, then content creators might have obstacles to bringing their content to market if a patent blocks the mechanism for that. But generally the content, if you're talking about the substance, like a work of authorship, a book, a training manual, things like that, that's the purview of copyright.
Thank you, Rich. Next slide, please. This ties into, it's a wonderful question, and Rich, it's a great explanation, and it ties into the next slide. Next slide, please.
That's the next slide, Alfred.
Did I think I covered it. All right. Oh,
no,
sorry.
this one is about disclosure and.
Okay, sorry. Okay, so it's the next slide after this. So we'll go to this. We'll do this first. So, what is your obligation to? Actually, let's do the next slide first, and then I'll come back to this if we can. So next slide. So what Rich said, this is what you can patent, and that was, I guess, basically the question. And this is an explanation as to what, and then what I'll go back to is to tell you how. So what can you patent first? So in the United States, we'll start with Tunisia. In Tunisia, you can file for a product. I have a new machine, a new Apple coring machine, a new knife, a new fork, a new mousetrap, a new light bulb. This is a product, a process for making cement, as we were just discussing earlier, a process for making a new machine, a process for making ice cream, a process for making a new software product that performs a statistical analysis on the growth of cows in the field. This is a process patent. In the United States, we have product process, we have product by process, and we have software, but we also have other things like design, and we have plant patents. So a design patent, picking up on what was asked, can you cover a design? A fashion design, a dress, is not patentable in the United States. It is patentable, it is protectable in most other countries, but it's protected through other kinds of patent rights, as Richard was explaining. There are copyrights, there are also design patents, and there are model patents that cover different things. But in the United States, you can patent a design. So if you have a pretty design for a fabric with fleur-de-lis, for example, you can patent that. It's called a design patent. It has a shorter term. And in China, you have pretty much the same things you have in the United States as well, as including design patents. Are there any questions on the content? Does that answer that question? Okay. Let's go back 2 slides, please. Okay, so what are the obligations, limitations? What do you have to do? So as we explained, you have to disclose your invention. First, though, I did see someone new join us. Besher?
Yes, hello. I just joined. I had another thing that I couldn't finish earlier. Sorry for being late. And I'm sorry for interrupting also.
No, you did not. Now, we like everyone to stay online, show who they are so we can see you. And we'd like you to just introduce briefly who you are and what your company is. That's what we've all done. I just want to do that. Okay.
So I'm Bashir from Majestai. Majestai is a data science company. We built technology reflecting the best practices in data science. That's the whole value chain of data from ingestion to prediction, with data warehousing and with visualization. So we've been in R&D since 2017, and we started our commercial prospection since early this year. So that's briefly.
Thank you. Thank you. Well, you just came just in the right time, because now we're talking about what it takes to how do you get a patent. We just started, so you're very welcome.
Excellent.
Thank you for coming. Okay. So first obligation to obtain a patent is you have to disclose it. You have to, for your invention. If you have a light bulb, you have to, or let's say you have a container, you have to disclose you have a body that has a cap that seals the liquid within the body. You have to make a enabling disclosure. Then you file it, it gets allowed, and then you have your patent. Some countries require you to exploit the invention, the patented invention, or you will lose your right within a short period of time. Many countries don't have that. Europe does not have that. The US does not have that. China does not have that. India has that. So if you don't practice your invention, because there are two concepts. One is you have a patent exclusive to you, allows you to exclude others, so you can be compensated for giving to the world the information and the benefit of your invention, for you to exploit for a fixed period. If you don't disclose it and you write something silly about it, just very general, it doesn't allow someone else to make the invention, because your disclosure has to be enabling someone else skilled in the art, someone like you, to make the same invention.
Can I make a comment?
Sure.
Just from an overall perspective, the whole point of a patent system, whether it's in Tunisia or the United States or anywhere, is to encourage inventors, creators, to disclose their ideas. Because only when you disclose your ideas can others see them and improve on them, and then promote what we call sciences and the useful arts, to make progress in the science field. Only really through full disclosure can others have the benefit of your development and then improve on it. And that's how we progress as a society. So in order to encourage inventors to do that, patent systems provide them a period of exclusivity where they can prevent others from practicing their invention. But the quid pro quo for that, the exchange for that, is that they have to give a full disclosure of their invention. You can't hide the secret sauce, we call it. You have to have essentially a blueprint for your invention so that others can understand it, make and use it without undue experimentation. So in exchange for that full disclosure, you get a period of exclusivity, and others can see your invention, improve on it. They can get patents on improvements of inventions. So that's the whole underlying motivation for a patent system.
May I just add to that, Rich, too, that, and then when the patent expires, anybody can practice that. And you have disclosed everything they need to teach them how to make and use it. So that's the other benefit too. You get the early disclosure so you can improve on it, but you also at the very end, anybody can make it, and you've taught them how.
Yeah, Alfred mentioned the cement that they used to build the bridges. Well, if that had been patented, we now would know how to make that cement. But that's been a lost technical contribution. So there are definitely positive benefits of the patent system, or so we don't lose. We have the benefit of all the developments, that we don't lose things. They don't. Escape us.
So whenever you're in Paris and you walk over one of those beautiful bridges, realize that cement, no one knows how to make that anymore. That's actually a true story. All right, so there's a question from Ahmed about the use of AI and patentability. No, you can patent a process. So you have to separate in your mind software the lines of code from the process performed. That's patentable. So we'll get into that in more detail, because that's the art of the patent lawyer. It's a complicated thing. And we're going to show you examples. So I have had the great fortune of representing Vermeeg. Many of you are probably very familiar with the Vermeeg software company, and Badruddin Wali, close personal friend of mine. And I've been representing him and his company for many, many, many years. And Sean Lee and myself and our team here have registered his patents globally. And we're going to show you an example of how you can do intellectual property, you can do software, and you can actually do AI. But it's a matter of the process in which you file. All right, so you have to disclose your invention in a way that enables one like you, skilled in the art, to make the invention. You do not have an then you have to pay money, fees. Everyone has to get paid. We all have to eat, including the government. So they require fees, and those are obligatory. They're not too terrible. Assuming you'll be a successful company, it will be the smallest investment that you make. But in the beginning, it hurts. And that's what this program is about. This program is to help you pay for and get you patents, because we want to show the world that Tunisian technology is important and it's here, and we can make good products and we can patent them globally. And that's really what this is all about. Next slide. Okay, so here, just quickly, we covered that. Those are, you can see the kinds of things that can be covered. Certain things are not covered, like medical surgery. If you have a new type of surgery, you can't patent that because it's against the humanity of people. So there are certain limitations that you can't do. Natural things that are occurring in nature, like a discovery of oxygen. You can't patent the oxygen. You can't patent the air. You can't patent the water. You can patent water with additives that you add that improve the water, but you can't patent H2O. Those kinds of things, fundamental natural things, cannot be patented. Algorithms, E = mc squared, the Pythagorean theorem, the Bernoulli equation, you cannot patent laws of nature. Those things are forbidden because they're for everyone. So those are the kinds of limitations you have. I see there's a question here. Let's see what the question is. What is this question? Vermeeg Palmyra, exactly. Are you familiar with that, Ahmed?
Yes.
Do you work at Vermeeg?
No, but I am a computer engineer, so I'm more connected in the IT world here in Tunisia, and I'm so proud of what they have made through the years.
Sean and I did the Palmyra patent, so
great.
I'm impressed that you even know that. So I know what that is. Okay, all right. Let's go to the next slide, please. Which company did you work for, Ahmed? Did you work for BFE or one of the other Vermeeg Wali companies?
No, I was in the I was head of the department in the public institution, and now I'm opening my own consulting firm, and I'm launching my startup, and I'm working in Promise project. So a lot going on. So we are more of documenting the entrepreneurial effort in Tunisia, and it's called NABDA right now. So that's why I ask about the contents and creation.
I understand. Okay. All right.
Thank you.
Thank you. So the invention, what are your requirements? What is capable of being patented? So let's talk about the water bottle. Okay, very novel idea. The water bottles have been in existence since the Egyptian times. They had vessels with water. So maybe you can't patent that because why? It's not novel. It's not new. There's nothing new about a bottle, okay? But if you make a bottle that has a material that preserves the liquid on the inside and makes it last longer, that bottle with a treatment on the inside is patentable. So the old bottle, not so much. The old bottle with something new, something novel, something inventive is patentable. Okay, so novelty is critical. Now, novelty is in your hands. You have the novelty in your hand. Your invention's novel. Now, if you give that invention to somebody else, you lose the novelty. So if you have something novel and you give it to someone else, you lose your novelty. How do you preserve your novelty? You file for patent. So in many countries, in most countries, you have what's called an absolute novelty bar. And an absolute novelty bar, so if you have an absolute novelty bar, you lose. So in Tunisia, in Europe, in China, in almost all countries, except the United States and a few others, you have to make a filing of your invention before you have a discussion with the public, before you give a presentation, even sometimes before you talk to an investor. There is a controversy if you talk to an investor for the purpose of investing. That may not be novelty barring, but it's a risk. So you need to file for patent before you make a public disclosure. Let's sing that together. You need, you really have to understand that. The moment you disclose it, if you put it on the web, you lose. So novelty and novelty preservation until you file is absolutely critical. Okay. Now,
of course, if you have a confidentiality, a non-disclosure agreement with a party and you disclose your inventive concept, pursuant to that contractual obligation to keep it secret, that usually does not trigger a public disclosure. So you would be safe under the absolute novelty requirements in most jurisdictions.
It's the NDA. Everyone here knows what an NDA is. So the NDA is your friend. Use it. Make friends with your NDA, because your NDA will save you, so you can preserve your novelty.
Yeah, start with the premise that anything that you develop would be a trade secret. Start with that premise and keep your information secret. If it's something like Coca-Cola that's unlikely that somebody else will be able to come up with it or reverse engineer it or something like that, maybe it's even more valuable to keep it as a trade secret. But if those things don't apply and someone could buy your machine, take it apart and figure out how it works and do it, then you're better off filing for patent protection. And that must be done before you disclose it to anybody. So it's very important to keep your inventive activity secret.
So it doesn't mean you have to be a monk with your technology and live underground and no one sees you, because that's not going to be a fun life, and nor is it going to be productive. So how do you, what's the balance? Okay, so the balance is you can talk to people. You can explain, I have a new invention for making cows happy, for making them fatter. I have a new invention for using artificial intelligence to help water crops by surveilling the humidity and the terrain. I have a new invention for making a plastic bottle which has special ingredients. That is not novelty barring, because you haven't said what it is. You simply said, I've got an invention that does this, but I haven't told you how to do it. If I haven't told you how to do it, that is not an enabling disclosure. It has to be an enabling disclosure, and a disclosure that enables one like you, skilled in your art, to make the invention. So if I say, here's my bottle, this bottle will keep this water in it fresh for 20 years. Here it is. I'm showing it to you. 20 years, upside down, sideways. I haven't told you a damn thing about how it does it. So you can advertise, you can go and promote, you can get invest. Ooh, he has a bottle that will keep my water fresh for 20 years. I want to hear more about that. I want to invest in that company. Sign my NDA and I'll tell you how. That's what you do, right? Very simple. The NDA protects you, and then you can say, you know, all I do is I put a little bit of salt in the plastic. Salt in the plastic? And it lasts 20 years, whatever's liquid. Could you imagine if you put salt in plastic and it makes a liquid, any liquid, and you knew that? Every company in the world will copy that. Coca-Cola. Think of all the things that are in a plastic bottle. Just go to the supermarket and see. And if you have a special ingredient, let's say it's salt, and no one ever thought about that. It's wow, salt in the bottle plastic, 20 years. You will be a trizillionaire. That's a new word I invented, so don't use it. I haven't patented it yet. Now that I've told it to you, I can't patent it. So that will give you a lot of power. So just to give you an example, a silly example, but it's an important example. You can discuss your invention. Just don't discuss how it does it. And then you can get people interested. Non-disclosure agreement. So that's the process. So to have an invention in the United States, to have an invention in China, to have an invention in Tunisia, it has to have three things. It has to be new. It has to be useful. That's what the industrial application has to do something. And it can't be obvious over what's already in existence. Right? So a plastic bottle is obvious, you can't have that. A plastic bottle with a coating, that's not so obvious, people know what that is. A plastic bottle with a coating having A, B, C in it might be novel, and no one may have done that. And if it has the product of letting the water or the liquid last longer for 20 years, it's very useful. Those are the basic elements of what's required for a patent. Are there any questions? Feel free.
I was wondering actually, let's say if you talk about your invention to some investor in Tunisia, so does your invention still considered a novelty in the US or not?
Yes, the US gives you 1 year. You have a 1 year, the US gives you a 1 year grace period. If you make a public disclosure, you have 1 year. However, you lose it everywhere else.
Oh, all right. Even if I talk about it to an investor here in Tunisia, right?
No. So there are rules of novelty. Rich or Patrick, do you want to explain the novelty rule?
Well, I just want to make one comment before. Don't rely on that grace period in the United States. It used to be, before they changed the law here, it used to be a very robust grace period. That if you made a public disclosure, you had a year and there were no negative consequences. But now that the law has changed in the United States, you still have a grace period, but there are negative consequences if you have publicly disclosed something and then you seek to patent it after the public disclosure. So I don't want to go into them in detail because we don't have a lot of time, but generally I would adopt the policy that you file a patent application before you make any kind of public disclosure anywhere. And go with that policy because it's safer. But if for some reason there's a public disclosure and inadvertently or you made a disclosure and then you decided patent protection was worth it after you made the disclosure, you still do have that a year to file something in the United States. But whatever that patent application you would file in the US may not be as robust as it would have been if you had not made the disclosure before you filed.
And maybe I will just add, if you're going to talk to investors in Tunisia about something, put in place a non-disclosure agreement before you have that conversation. And that will protect you from the absolute novelty bar, because you will still be able to file for patent after making a disclosure under under an NDA. So that's what you.
But we have a secret weapon for you, a very special secret weapon that we're going to reveal. This is like a TV show when you're waiting for the punchline at the end. So we have a secret weapon that will help you, but we're not going to say what it is right now. We're going to keep you in dramatic suspense.
There is a question. Somebody said, so the NDA is the ultimate shield? No, it is not the ultimate shield, because let's say you disclose your invention under an NDA to an investor. The investor then turns around and makes a public disclosure of your invention. Well, what is your recourse? You have a recourse of a breach of contract against him, but you've still lost the ability to seek patent protection. So the ultimate shield is filing a patent application before any kind of disclosure. So hopefully that
Rich is coming close to the secret weapon. He's getting close, but we'll keep you in suspense. So it's the drama of patent law. Very well done. Okay, next slide, please. Okay. How is an invention judged to be new or novel? Well, you have very important people like Dr. Farley here who make these decisions globally. Isn't that true, Patrick?
Absolutely.
Okay. So,
I think we've covered most of the stuff on this slide, actually.
What do you say?
I think we've covered most of the things on this slide.
We have. There's the NDA that protects you from the disclosure you make, but it doesn't protect you if the person discloses. So that's what Rich was talking about. Certifying an agent, revealing an invention to a certified body. That's a very limited exception. Doesn't usually. So for example, if you have to get governmental approval for a drug, you submit it to your equivalent of the Federal Drug Administration, that is sometimes not considered a novelty barring event. That's a government agency for approval. Grace period, we covered the 12-month grace period. And most of this has already been covered. So new and novel, those are the important things. Next slide, please.
There is a comment, Alfred, from Anis.
Anis, what is your comment?
Some need
freedom to operate. Okay. Very good question. So when you are going to come up with your invention, your concern is, has somebody else invented it and do they have a patent? So this is the general patent lawyer rule. There's always someone in front of you and there's always someone behind you. So you don't really know unless you look. And sometimes when you look, you don't know. So the default should always be to patent when in doubt. But there are things called freedom to operate opinions. So you can go, how many of you, by show of hands, just like this, how many of you have ever gone on the US Patent and Trademark website? Okay. How many of you do not know what that is? There you go. Okay. So, Bashir, let me explain this to you. If you go on to www.uspto.gov or Google Patent. Have you used Google Patent? Okay. So Google Patents, just type in Google Patent. These are search engines. And you could put in words of your invention. So, Asma, what is your invention? Tell me again what that is, Asma. You're on mute.
No, I'm not. I don't have a startup. I'm just a part of the accelerator, so I'm investing in startups.
Okay. So Bashir,
another site is eSpaceNet.
eSpaceNet.
That's ESPACENET. You'll be able to search all of European patents, and it'll show you the families that were filed outside of Europe. So it'll include the US and other jurisdictions too. So that's a very good resource.
And there's a slide later in the presentation that will list those websites for you.
Right. So let's go to Mumi. Ahmed.
Hello.
What is your invention? Tell us.
Actually,
What was your invention?
What was your invention?
Tell us.
It was a trick. It was a trick question. It's a test.
No, you just spent like 30 minutes talking about the gray sparrow, or whatever you called it. 1 year in the States. And
remember, don't tell me how. Just tell me what.
Generally, what is your technology about?
What is your technology about?
Actually, our technology is to get prevention, prediction. Prevention is the other word. So to get prediction and give decisions to everybody in the dairy ecosystem. So it's software.
So
more than to be hardware. Yeah.
So to disseminate information about the agricultural area in which they're interested. Okay.
The dairy.
All right. So you would go to the USPTO website or to Google Patent or to eSpace, and you would type words, and you all know how to do searches. You type in a Boolean string, and it'll pop up patents. And you can see the kinds of patents that are related to your invention. That's what you would do. You would look for other patents, and then a lawyer would review that and give you a freedom to operate opinion. Or you, your own, could look, oh, this guy, this patent looks like it blocks me. But it's very complicated. Patent claims, what a patent says and what it means are two different things. Because lawyers write things so you don't understand it. That's why we have a job. So the whole point here is it's a very complicated thing. What a word means to you may not be what it means in patent law. So we'll get a little bit more into that as we go.
Just a little thing, Alfred, if I can.
Please.
We all know that it is necessary to pass through a patent or IP firm due to the complicated processes all over the world. Even here in Tunisia, it's a complicated process. We all know that. So I don't know if we can just move forward and focus on the process, how to patent a process, how to patent a. I have seen the software thing in the US, in China. We don't have that here. Maybe as an entrepreneur here, we need to work forward with promise to get software patented here in Tunisia, because there is a lot of value coming from software.
Of course.
And in those days, and we need to focus on that.
Yes, you're absolutely right, and we will get to that. Just to give you, since you mentioned it, what is the historic objection to software? Why are we not patenting software? Why? The question. The reason why is because many countries resisted the idea because it was so new and so novel. They didn't really understand what it was. They didn't know how to search it. So a patent office, if it's a machine and there are publications about the machine, I have a new car, a new engine, people publish this and they file for patents on machines. So the patent office has a body of literature that it can work with, and it can search and say, no, your car is like this car. But software, no one knows what it is because it's inside a computer and it's not published. It's not made public. So it was very difficult for these patent offices to look at the prior art because they didn't know what it is. And so they didn't have the capabilities of doing software patenting. So they resisted it for many years. This is really the reason. That has changed. The United States took the big leap and said, no, this is an invention, because it obviously billions of dollars are made from it, and it does things. So it has to be an invention.
Sorry, Alfred, again. And maybe the second reason it's it's very, very difficult to verify and to prove there is a copycat of that, or to check on if there is a copycat. In hardware, it's obvious, it's very easy, but in software too, it's very difficult to check on.
Yes, but that's enforcement. That's enforcement. That's not getting the rights. That's enforcing the rights. A different thing. But yes, you're right. You're right. But let's continue on. I think it will.
That was also the difference between copyright and patenting, because the copyright is the actual expression of your algorithm, of your logic. It's the code, it's the specific code, but the patent will cover the concept, the functionality of your software without requiring somebody to actually copy the code. So the patent gives you broader protection. It protects your functionality rather than just the expression of it. So you can, in enforcement, you can tell if somebody else's software is doing the same thing your software is doing. It may not be written the same way, but you can tell what the function is. But that and we'll get into it. Sometimes function, and another reason that a lot of jurisdictions don't like software patents is that many people, I mean, I lived through the internet bubble as a patent attorney. Many people were seeking to protect very common processes that were done without the assistance of a computer. So they were just merely applying a computer to do a common process, like a bookkeeping function or something else. So there was really nothing underlying that was new. It was just now being affected on a machine. And that was a difficulty for patent systems to deal with.
So let me give
final
you
final thing, Alfred. I'm talking here from a operational perspective and day-to-day working with algorithms and things like that. The question is, like for us as a startup, our main value came from an algorithm, an AI model. If it is known, we have no startup, we have no value, we are dead. But we are obliged that to have team member to work on that algorithm, to know it. So maybe the best way to protect our value is to make, like in the employee contract, to make a clause to say you don't have to say this thing. That's okay. But if it goes in the hand of another company, we cannot protect ourselves. It came from a hacking or a Trojan or whatever, because if we can protect that, if it is known, even the other company has that model, they cannot commercialize it. This is why we are asking for that. Why, basically, why I am here.
right, and so you're right, and you need counsel on how to do that, because you can't figure it out on your own, because it's complicated. But there is a path. I promise you, guarantee you, there is a path for protection. But it takes a little bit more investment of knowing what you're doing, how you're doing it. This is how it works. So we're just scratching the surface here. So a little quick note on software. I started writing software code in 1970. I assume most of you were not around in 1970. So in those days, it was very simple machine language, easy to copy and put into another machine and it would work. Today, it's just cannot happen that way. But very things are done in blocks and in pieces that you borrow and use or buy or license from others. It's a different way of conceiving software. But software, it's not so much the software itself, it's the thing it does. It's the process. You have to think about the process. What is the process? AI is a solution, but the process is what you're going for. And so we'll get a little bit more into that and explain to you how that would work. What do you think about Solue envelope? I don't know what that is. Anis, what is that?
That's when you put your idea in an envelope and you mail it to yourself.
Oh.
So, yeah, don't do that.
Worthless, has no value. It's a wives' tale, as they say. It's forget it. Okay.
It depends on the country. For instance, if I take the sample of France, the law in Europe allow what we call envelope solo. So the idea is not to just send it by email. The idea is to give it what we call, it's a kind of law, it's a specific law who can protect the idea in a kind of envelope. And this is another way of a protection in Europe, which is little bit different from a patent, and we haven't to divulgate the idea in public because mainly if we have a patent, the startup had to have enough money to protect the idea worldwide. And since a startup cannot have, by definition, a lot of money to inject directly inside the patents, the idea is to have another mid-between of protection until I have enough money to put patents.
Right. Well, in the United States, there's something called a provisional patent application.
Oh, the
So
secret.
I would opt for that over any sealed envelope or anything else.
So
the other thing is, sealed envelope was useful in places like the United States when you had issues of trying to determine who came up with something first, so that you would mail something to yourself, so you would have proof that as of at least the date you mailed it, you had come up with that. But the United States has now moved to who was the first to file in the patent office is the one who's granted the patent. So that's no longer helpful. If you're going to be mailing something, you should mail an application to the patent office. That's what you should do.
So Anis, let me just give you the historic perspective of that. Europe has what's called, France in particular, has what's called moral rights. Moral rights are the right of the individual, the moral right to their intellectual. No one can take what you have in your head. It's an old concept, but it is a European civil law concept. And so if you put in an envelope what you invented, you have a document, as Patrick said, that establishes what you had when. And then you would bring an action under the law of moral rights. It's very weak. It really is more of a myth than a reality. But that's where it comes from. We don't have moral rights in the United States. We have a different body of law, but that comes from a very ancient concept of moral rights. It comes from the Romans. It's an old process. You're better off with the new process. So we'll talk more about that. Okay, so databases, we discussed them. You have one in WIPO, the World Intellectual Property Organization, Google Patents, USPTO, and then you have all these others. So you can look them up. They're very, very helpful. Let's move to the next slide. Okay, so inventive step is what's used in Europe, but it's also called non-obvious. So your invention has to be novel and not obvious. So a bottle that is clear plastic, it's obvious. The bottle is not new. A bottle is not new. A bottle of plastic is not new. A bottle with a label, not new or obvious. But a bottle with a cap that can be used, that also preserves the liquid from being oxygenated, that can be, although a cap is obvious, it is obvious and not new, but what you make the cap from, or if you have an insert in the cap, this can be an inventive step, something more inventive than, and that's what is the essence of invention. Any questions on this? It's a complicated issue, but we tried to give you as much information about it, about novelty and obviousness. Next slide. Let's try to make some progress through this. Okay, the pencil. What is patentable about the pencil? As a use case, pencil is very novel. It has lead.
Alfred, it's an eraser pencil.
Right. I know. Yeah, it's like the water bottle, right? So you have a pencil. The pencil has been in existence forever, right? So what is the technical solution that is solving? It's a useful device for writing. However, if you add an eraser to a pencil, like you add a special cap to a bottle, that makes it patentable. That's the inventive step that is used in that context. Next slide. Any questions on that? Next slide. The Apple Watch. The watch is not novel. No one can get a patent on a watch. However, this is a very inventive watch. It's novel because it communicates with your phone. It's a camera. You can talk into it. You can take pictures. You see, obviously, the inventiveness of it. It has obviously clear applications. Is that clear to everyone? Why the Apple Watch is patentable? Right? Any questions on that? Next slide. Ownership. Okay. This is an important thing for all of you. Next slide. Who owns the patent? So inventorship is determined by the person who invented. So if Ahmed has come up with this concept and he worked on it and developed it, he's the inventor. Now, if he goes to a third party, a vendor, and says, I need your help to perfect my invention, I need you to make a stand so I can put my invention on it. That person's not an inventor, they're just a technician. But if the third party helps you make the invention, they're also an inventor, they're a co-inventor. So when people collaborate in a group and you work together, then you are collaborating. In the United States, you must name all collaboration inventors. So if you have other partners who are contributing to the invention, you have to disclose and name them. They are inventors. Under the US law, the US Constitution requires, it's one of the oldest laws in the world, because the right of patent comes from the US Constitution in the United States. In other countries adopted the patent system following that, but we are one of the first in the world to have created patents. And it's one of the most fundamental rights of the United States. And it's an individual right. So the individual has to be recognized for their contribution. So Anis, what you were talking about earlier about the envelope, the thing, moral rights is the equivalent. In Europe, the moral right of the individual to the invention is what it's called a moral right. In the United States, it's the right of invention under the Constitution. They are parallel. That's how they join. So the inventor is the person who invents. So if you work with somebody and you collaborate, they're also inventors. So you got to keep that in mind. And that's who any questions about inventors and who an inventor is.
Yeah, please. Yeah, I have a question. In fact, when one of an employee is working in a company, make an invention, this invention belongs to the company or belongs to the inventor?
It depends. The answer is it depends. It depends on your agreements. If you have so all of you have employees, you should have an employee agreement. You should have a corporate agreement that defines and explains all these things. If you have an employee and that employee invents and you have no agreement, it depends on the law of the country and the law of the state in the country. So in the United States, if you have an engine, if you're Boeing making an airplane and you have an employee who invents airplanes, the company will own it because that's the purpose of the employment, most likely. In Europe, not so much. In France, you have, again, moral rights. If the company, if someone invents and you don't have an agreement, then you are in trouble. In Tunisia, you should have some kind of agreement, but typically in Tunisia, if it's an employee employed to invent, then you would have a right of ownership. However, if it's your janitor or someone who cleans your toilet or who parks your car is your employee and comes up with an invention, you don't own that because you did not hire them to invent. You don't own them as people. If you employ someone to make a product for you, you have a right to invention as a corporate, as an owner. But if it's not in the line of the invention, they come up with their own ideas just because they're your chauffeur or your cleaner or a friend of yours. You can't claim right of ownership. So you should have agreements in place. Very important to have.
There could be a wrinkle to that. If you have your chauffeur, as Alfred said, but he comes to you with an idea and you give him resources and you let him use your company resources and time to develop the idea, you might have rights in that invention. So it's very fact specific, it's very jurisdiction specific. But the takeaway should be that you should always have agreements that clearly spell out the relationship and the expectations.
Yeah, that's the only way to know for sure on how to protect something. Is that clear? So,
and those agreements should include a present obligation to assign all rights in all inventions and intellectual property developed. So it should say, the employee should say, I hereby assign all rights into any developments that I'm involved with, any IP developed. It shouldn't be, well, I agree to assign in the future. It should be a present assignment.
I have a question. This agreement can be included in the contract between the employee and the firm, or it should be separate, a document separate from the contract?
It could be both. If it's separate, in some jurisdictions, if it comes after the employment started, there might be an obligation on the employer to provide additional compensation or consideration for the agreement. For example, in the United States and some of the states, if there's been an employment relationship, but then after the employee has already been working, the company decides to implement an IP assignment agreement, you usually have to give additional consideration for that agreement. So, money, extra money. Just the continued employment isn't always enough to satisfy the consideration for that agreement. But it's, again, that's very jurisdiction specific.
Thank you.
I have a question, please. Another one. In fact, while filing a patent, you have to fulfill the name of the inventor. And if I want to put the patent in the name of the company, it's a little bit complicated. So how does it work? What's the best way to do it? To say the patent it's for the company, like for investor or for whatever.
So it depends on where you are, what country you're talking about. So in Europe, the company can claim rights of ownership and generally discloses the inventors. Why? Because if they're going to file in the United States and they don't do that, it's invalid at the start. So the United States requires identification of inventors. And so if you plan to file in the United States at any time, you must name inventors or your process will not succeed in the United States. So
the other thing too is that some laws in other countries, like Germany, for example, requires that the inventors be compensated for their invention. So you need to identify them because they're going to get a right to additional compensation for their contribution.
These are general laws that are generally written to protect inventive people. And so you must identify them. You have an obligation to do so. And you cannot put the president of the company because they're the president. If they were not involved as an inventor, they cannot be named. Just because you own the company does not mean you're an inventor. You have to invent. If you don't invent and you simply own the company and your name is on that and it's just your name, your patent is invalid. You will invalidate your patent if you just put yourself down as the president and that's it. Don't do that. Many people do that. They misunderstand. They think I own it. It's mine. I paid this person to do it. It's not how it works.
From a practical perspective in the US, what we do is we file the application, we name all of the inventors. We also file an assignment. We obtain a written assignment, even if there's employment agreement already requires it. We file a written assignment agreement specific to that patent application from all of the inventors to the company. And then we name the company as the assignee owner of the application. So the application will have the name of the company as the owner, but it will also identify each inventor under the section inventors. And you'll see that even on an issued patent, you'll see the name of the inventors, but you'll also see the name of the assignee of the application and the patent.
Okay, so inventorship. Next slide, please. Is this it? Mine's a little different. Where are we? I have this one.
And we've gone backwards. We should go forward.
Yes. Don't you see the right slide, Alfred?
Next slide.
So this one? What?
Yes, the next slide.
For the process. Okay.
No, I'm looking for this one. Where is this one?
So it's here.
Do we want to just jump to software patenting? Because it seems to be that that's what most people want to hear.
All right, yes, well, hold on. Let's see.
The time is running out.
Yes, let's go to the next one. Let's go forward. Keep going. All right. So overall process, we'll do this quickly. So for your benefit, this is the process, the comparison of the different types of patenting. Go back. This is the kinds of patenting that goes on. These are what are required. Tells you what you can get, not get, just so you have it. No plant patent, no design patents in Tunisia, China, what they have in the US. So you get a sense of what kind of rights you can have. Next slide. All right, we talked about you file a patent, it gets examined by an examiner, it's published for opposition, substantive review, and granted if it's novel and new, if it meets all those requirements. That's the physical process that happens. Next slide. What is in a patent application? So the secret weapon that we were talking to you about is called a provisional patent. A provisional patent application is a way for you to put in writing what your invention is and you file it in the US Patent and Trademark Office, for example. No other country has a provisional application system that I'm aware of. And what this does is it protects you for 12 months until you write a full patent application. It gives you an extra advantage. Rich, you wanted to say something?
Yeah, well, this is sort of further to the envelope question, right? So this is a cheaper way to get a priority right, to get to put your line in the sand that this is my invention, I invented it now, and I'm claiming priority rights to this date. You can file this provisional application. It doesn't have to be perfect. It doesn't have to have all the I's dotted and the T's crossed. It doesn't have to be written perfectly. It could be just sheets of flow charts and things like that. As long as it discloses the invention, doesn't have to be pretty, but as long as it discloses the invention, it will meet the criteria of content. You could file it with the Patent and Trademark Office. The filing fee is low. You could do it yourself if you had to. And it gives you a priority date. The date of filing gives you a priority date you can rely on to avoid prior art from others and other advantages. But it doesn't get it doesn't get examined by the US Patent and Trademark Office. It gives you the right to say patent pending in connection with your developments, which might have a chilling effect on competition. And it gives you a year to follow up with a full-blown patent application. What it also does is it allows you to capture the evolution of one of your developments. So once you hit a milestone, you may not have a complete development yet, but you might have reached a milestone. You can file a disclosure of the invention up to that point, and then you can file another provisional application when you reach another milestone, and you can file even another application after. You can file as many as you want, and then follow up with a full. When you follow up with a full application within that year period, you can claim the priority to all those multiple provisional applications you filed.
Okay.
So it's a cheap way to get a priority date and to get your foot and to start the process. So if during that year period you realize the development isn't commercially sound and you want to move on to something else, you just abandon, you leave the provisionals alone. They're not published. Nobody can see them. So you haven't disclosed your invention publicly, but even though you may feel that it isn't commercially viable and you moved on to something else, at least somebody else isn't going to free ride off of your efforts.
Okay, so let's talk about, so what is a patent application? So we've got a provisional, which is a special thing in the US, which is the secret weapon. And we have a regular patent application. Let's go to the next slide. Okay,
At this point, we should say that the regular application does have very specific requirements of what it must contain, unlike the provisional, which could be, just anything that you send to that patent office. Because actually, the patent office doesn't even review your provisional application.
Right.
Just
So typically, the typical situation is we get a client calls and says, hey, in 2 days, I'm giving a paper at Harvard University, and I'm going to talk about my new invention. Well, you say, wait a minute, you better file something before you give that public disclosure. So we'll take the client's notes, maybe whatever printouts he's had and internal materials, put them all under one cover and just file them with the patent office.
Okay, so let's sort of reorient ourselves. We're going to talk now about what a patent application looks like, and then we'll show you some examples. So a patent application is very specific. It has to have a certain format in order for it to be proper, to be correct. So it has to have this structure. It has to have has a title. It has a description of the invention. It has an abstract. It has drawings. It has claims. And it's very specific in what it looks like. Let's go to the next slide. So this is an example of the Apple patent that we were talking to you about that made the $1 billion. So you can see it has a number, but it has a title, 54. It has the names of the applicant, Apple, 71. And 72, it has the inventor, who the inventor is. Assignee, the owner is Apple because they had what's called an assignment. And it shows you the date it was filed, number 22. It shows you what prior publications, this is a provisional application that was probably filed for, and then the related priority documents that follow it, and what other patents claim rights to it. And then it has other information that relates to things that are not so important for you today, like the art units, the examiners, and the like. But this is the cover page of a patent. Next slide. This is the drawing that covers the device that is part of the patent. It's called a patent drawing. You can see it has a very specific three-dimensional look to it. It has numbers that identify the elements, and that's a patent drawing. Next slide, please. Patents are done in columns. You have column 1, column 2, and the lines are numbered. You have so you go, when you refer to something with a patent examiner, you're going to talk about column 1, line 15. That's how it's so specific. You want to be able to refer to the specific lines and the specific language.
Alfred mentioned the drawings before. In a software application, you're not going to see a picture of a product. So what you'll put in there is the flow chart, the logic underlying the software. You're not going to put the code in. You might want to put some pseudo code just to show, you know, the way it could be effective. But we never put the full-blown code in there because you don't want people copying the code, and that's protectable by copyright. But generally, you want the logic. So you're going to have flow charts. You might want to have, if it's generating a result or it's improving the performance of the computer, you're going to want to, you know, some sort of depiction of that if it's possible.
Right. So this has very specific. So you've got the title, you've got the field of use, the background, the summary, detailed description, description of the drawings. These are very specific things. In Tunisia, what do you need to file? Nothing like this. It can be, it could be a very simple explanation of it as its own format, and you can file it, and it will be allowed. Because the Tunisian Patent Office does not do substantive review. They don't review the content. They simply receive it. They make sure it's in the proper language and that it has the form that it needs to have, and then they issue it. So that is not uncommon. Italy does that. Many countries do that because they don't have the resources. They don't have this infrastructure to do substantive review. It's very expensive. It takes a lot to do. So there's nothing, you know, embarrassing about it, but it isn't how it works in most other countries. So if you file a patent under the Tunisian structure, it will not be compatible necessarily with international filing standards. Same as if you filed a patent in Italy. So it's not a negative thing. It's just how that country has its system. So you follow the international practice. If you follow the international practice, which is what this is, then you can file anywhere, including Tunisia. So what we're going to talk to you about is filing it at an international standard. It's very important. Any questions on that? Okay.
I'll just add, Alfred, on the previous slide, I'll just add that this slide shows what is required in terms of disclosing your invention. It's how to make and use the invention. This is you teaching the public how to make and use the invention. Where the claims we're going on the next slide is a bit different.
Next slide. So these are the patent claims. Now, I'm just going to read one to you very simply so you can see how it doesn't make any sense. So you have an electronic device comprising a housing, comprising a transparent housing component having a curved exterior surface formed of a single layer of transparent material, a curved exterior surface comprising a central portion surmounted on at least two sides by peripheral portions, each peripheral portion having a curvature that is greater than the curvature of the central portion. How's that going for you so far? So it's very complicated language. It's very complicated. So you may read that and may not understand it. And that's why it's important to talk to a professional who can help you understand what that means, because it's written in very precise legal, technical language, and you're not trained in that. And the reason it's written that way really is not to exclude you, but it's how the law developed. This is 250 years of patent law and develops these kinds of language. So it's really not for a layman. It's not for a person who doesn't have experience, because this is not easy language. So it requires a specialty. It requires a patent lawyer to do it.
Somebody asked a question about protecting hardware inventions in China.
Yeah.
Sean, you want to?
Well, I think he can chime in and whenever he feels like to. China has a very young IP system. Basically, when the country was formed, it was on a very communist and socialism ideology. So basically, at that time, intellectual belonged to the people. So there's no private ownership of anything at that point. So intellectual property is treated like land, and it belongs to the people. So there's no patent system, copyright system, or trademark system at all until in the early 80s. They realized the economy cannot function without a proper intellectual property protection system, because none of the international companies wants to do business in China if they cannot protect to some degree their intellectual property. So they introduced the first version of patent law in 1984. That it's only been a little over 20-something years for China to actually have a fairly robust patent system. It's basically modeled after the European system and also a little bit on the US system. So a lot of the general principles are transferable if you understand the European system quite well. A lot of the ideas are very transferable to the Chinese system. So in terms of the biggest complaint I think we have over the years is the system is not particularly robust in terms of enforcement. So at earlier versions of the Chinese patent law give you a very small upper limit for damages if a infringement is found. And then the enforcement in terms of injunctions and basically stopping the copycat company or company who stole your technology is not particularly robust. And that has been changed over the years. I think the latest draft of the amendments of the Chinese patent system actually brought the damage cap up quite a lot. And the other complaint that we had over the years was the Chinese court system was very incompetent in terms of dealing with technology issues. The judges are not trained in any way, mostly in technology areas at all. So to deal with that aspect of it, they actually introduced the specialty court systems, the intellectual property court systems in major cities. I think we have at least 3 or 4 of them now sprinkled around the country, mostly in the economically developed areas, Beijing, Shanghai, Guangzhou. I think one in Western China as well. Is it in Chengdu?
I think it's in Shenzhen.
Is it in Shenzhen or is it in Chongqing? I think they have one in the Western China as well.
I think it's in Shenzhen, but they set up a patent research center in Chongqing, I think.
Okay, so that's probably what I was thinking about. So enforcement has gotten much better in China over the last 25 years. So in terms of hardware, so from a business perspective, when you go into China, because a lot of the electronics are actually made in China, just because it's a little bit cheaper to make there. I think the supply chain is there, all the parts are there. Skilled labor is relatively cheap over there for this type of purpose. So a lot of companies do make their hardware in China. So I think the first solution is a business solution. You have to trust your vendor. You have to understand how they operate. Are they going to, we always joke that they run an extra shift if the product is really, really good, instead of making the amount that they're supposed to deliver to you. They run an extra shift or run a couple more days off the line. So they have this extra batch of product, which is actually genuine product, but not ordered by you, and they will just sell it off out their back door. That has been always been a problem. But the thing is, it's about picking the supplier, understanding the way they operate, and not falling in traps with dealing with people who are a bit shady and not respecting your long-term relationship with you.
So the short answer is you can patent a device in China. Let's talk.
You definitely want to have IP rights registered or patented in China. Your trademark, it's very, very important to register your trademark, even if you're not selling. It's very important to actually register your mark in China. If the device is patentable and you're seeking patent protection elsewhere in the world, you probably want to extend that application into China as well. It's a little expensive because you have to translate everything into the Chinese language, because the Chinese Patent Office does not examine a application in any other language, in any language other than Chinese. But you have to, but that's sort of the cost of getting a patent there.
Okay, so let's move forward. Let's move, Sean, thank you very much for that. Let's move forward to the next slide. So this is the design patent. This is a design patent. It just covers the features of the design. And this is the one that earned Apple $1 billion in royalty. So it's a very different structure, but it's got the same thing. It's got a title. It's got, it has a description of what the invention is just by the title. And then it has one claim. I claim the following drawings, these figures. So let's show the next slide, please. And this is what, next slide. And this is all that's in that patent. And this is what you can see. It looks pretty much like that, the old Apple design. And this was copied by Samsung, and they paid Apple $1 billion. It only cost maybe $10,000 or $5,000 for this patent. They made quite a huge investment. And so you can see the value of something like this. This is a design. It's not a machine. It's not a utility patent. It's a patent on a design. But they can have great value. Let's move forward. Next slide. Okay. So patent fees, you got to pay the government fees. How much does it cost? Average patent cost to get a patent on file is about $10,000 to $15,000 US. The prosecution is probably another $10,000 to $15,000. And then you have to pay a issue fee, which is about $1,200. And so it can cost you anywhere between $10,000 to $30,000 to get a patent out of the US. In many cases, it's much, much more money than that. And it's about the same in most European countries. So those are typically the costs overall of a single patent. Many companies have thousands of patents to cover their inventions. We're simply talking with you about getting you a simple, an important patent, one or two, which the government is planning on supporting you to get. But these are just a summary of the transaction fees and costs, and you could look at those. But this is talking about, you can see the application fees. I'm not sure what these are just government filing fees. This is what the government is charging you. But what I gave you was the legal costs associated with getting these things on files. Those are going to depend on your attorney's fees, which are kind of listed on the side here.
There's also fees such as translations. For example, if you're filing in a country that requires the patent application to be in the language of that country. So you'll have to keep that in mind too. Those can be very expensive as well and add greatly to the cost of the patent.
Right. So in most countries in the world, you can file in English, except China. You have to file in Chinese eventually. And so you want to, usually most patent applications are drafted in English and filed in English worldwide. So that's the currency, that's the language of the currency today. So next slide. Software patents, we got there. Okay. Software patents are patentable in certain countries. Certain countries exclude them. Tunisia excludes computer programs patentability. However, you can claim a process. So if it's a process for squeezing orange juice, and you use a software to do that, you can still patent that process, but you have to do it in a way that doesn't say it's a software patent. It can be done. It has been done. And it will continue to be done, but it requires a certain specialty and experience to get that done. The United States says patents that are software-based are patentable, but there are restrictions. A very famous example is the one-click. How many of you are familiar with the one-click? How many of you are not familiar with the one? How many of you are familiar with Amazon? Right? Everybody knows Amazon, right? Okay. So Amazon created the one-click, meaning you pick your product, you have one click, and you're done. Then it comes to your house. You don't have to put in a whole bunch of other information because you pre-put the information in. And then you click it, and it just comes to you. It was a massive innovation in selling products through the internet. It transformed the world into a commercial entity. So it made a huge change in the way that commerce was done. The one-click was a very important patent. We lost our screen. Did we lose you, Asha? Aisha?
I think Aisha has connection issues. Just 1 second, please.
Okay, okay.
I could also share my screen if necessary.
Yeah, if you could do that, Patrick, that'd be fine. Oh, Aisha's back.
I'm sorry, I had an internet issue. I'm gonna share the screen. Sorry. Where did I leave? When did I leave?
Oh, Patrick has it for you.
No, she's got it right there. It's correct.
Oh, okay, good. So you are where we are. Okay. So we were talking about the one-click patent, how important it was, and it changed the way people bought things. But it's software. It really is a software process. But the process is to purchase a product using one step. That was the innovation. We're not patenting the software. It's a totally software-driven solution, but it's the process that was patented. So in the United States, software itself is patentable, as well as the process in which it applies. Some countries have implemented, have prevented computer-implemented inventions. That's going to be a country-by-country basis. However, we have obtained patents for the Vermeer Palmyra software system worldwide. And we can show you that next slide. Any questions on this? You might have questions on this. Any questions? Okay. So for a use case, for example, of software patents in the US versus Tunisia. Tunisia prohibits the software patent, but it does permit process patent. So a process for analyzing data using steps like this, that can be patentable and should be. So it's the method of patenting that's important. In the United States, there are limitations. If it's too abstract, if it's too vague an idea, software for controlling the world is not patentable. So if it's too abstract, it won't get anywhere. So you really have to focus on what the process is and how it's implemented.
Abstract sort of also means that it doesn't have a technical effect.
Right.
So if you've got software that improves the functionality of the computer, it increases processing speed, for example, that's not abstract, that's patentable. But if it is abstract, if it's implementing a function like for the stock market, buying low and selling high, well, that's an abstract process, but it doesn't necessarily mean you can't get software protection for it. But you have to move on to test other criteria for patentability.
Right. So are there any questions on this?
Yeah, I have a question, in fact. Since software is the law is different from one country to another and from European to another. Are you saying that the best way to do it is to patent the process in order to go through PCT and make an extension, for instance, from Europe to USA, and by this way we avoid to pay for the same invention two lawyers and do it in this way?
Yeah, you have to file it. You need to prepare your application using the construction that is most accepted by most countries, right? So you need to use the international standard. And the international standard on software patents is really established by the US. We were the first to do this, and it has slowly been accepted in other countries. So if you follow that standard, you're going to be more or less acceptable everywhere else.
And you still need to give a complete description of the invention so that somebody of ordinary skill in the art, some hypothetical person of ordinary skill in the art, can make and use it without having to do experimenting, right? So when we're saying you approach it as a process versus as the software itself, that doesn't really bear on the disclosure. The written disclosure is going to be a complete description of your invention and how to use it and how to make it. But that really goes to the claims. And that's really where we come in as the patent lawyers. We can craft the claims based on the jurisdiction you're in to satisfy the requirements of that jurisdiction.
So on this slide, if you look at the technical requirements for the European standard, it must have technical character or contribute to it, in particular because a technical problem is solved by using technical means or a technical effect is achieved, technical interactions occur, or technical adaptations are affected. So it's much more linked to a technical effect. And that's really what we've done in the US, is that it has to have a technical effect. So it's a process for doing something. And that will get you over the line. So if you say a software for, you're finished. If you say a process for, you have a starting point, right? So that I think that helps you through. Next slide. Avenues for patenting. So where do we file? Next slide. Okay. So there are international filing systems that have been developed. The PCT that Anis had mentioned is the process that people use. But you have to file someplace first. You have to file either in Tunisia, you have to file in Europe, or you have to file in the US. I would recommend you do not start in China, because that requires a much more complicated process. You have to have an expensive translation. So I don't think anyone's going to file there first. Most people file in the US first because it's the largest business market, because and then second is Europe. But Europe has multiple countries. So it has a regional filing. You file in the EP for a European patent, which then means it has to be localized in each country. So many people start in the US because it's one country. If it's filed there, it can be filed everywhere through the PCT. And that's the process that's generally used by most countries, most companies, almost everywhere. So how does that work? You know, as patent lawyers, we file everywhere. We have the ability to file in every single country. So our law firm is a general practice firm, so we represent businesses and their agreements, but we also have a patent department, and which I'm the head of, and which these are members of, and we file patents in the US. We file them every country in the world. We do that through what's called a foreign associate, associates that we work with, and all patent lawyers everywhere have a network of lawyers that they work with in each country. and you use the Patent Cooperation Treaty, the PCT system, for filing everywhere. So how it works is this. You prepare your patent application.
Well, almost everywhere. Not every country is a member of the PCT, but most of the industrialized nations in the world are. So there are a few exceptions, but
yeah, I think the more economically important one is Taiwan.
Taiwan's the one exception, but I'm not sure you're going to worry about Taiwan. It's not the biggest market. So most countries of your concern will use the PCT. And how does it work? You prepare your application on the international standard. Then you have to have what's called a receiving office. And you have to file it in the US, or you file it in The Hague in Netherlands, or you can file it in France, Germany, Spain, and or Tunisia. Tunisia is a member of the PCT. The problem with filing in Tunisia is that the standards of Tunisian patent applications are not international. So you have to prepare it in the international standard, and you can file it in Tunisia. And our recommendation is that we would file your patent application in the countries in which you think you want to get investments and get the most interest, where you think the market is. So a lot of people will file Europe or the US. China can wait, but you can preserve your right by filing through PCT. So the PCT system allows you to file, let's say you file in the US and you file the PCT application in the US, designating the countries you want. And you can designate all countries in the PCT by paying one fee. And that filing in the US gives you the equivalent of a filing in each country in the world by paying that PCT fee. And when you file, let's say in the US or in The Hague or France or in Tunisia, you have a certain amount of time to file your national applications. Usually it's 31, 28, 29 to 30 months. And within that period of time, you then have to file your national applications. But by that time, you've already had the process of patent examination and a search that will give you your prior art. So this is a complicated process, but what happens is you file your patent, it gets examined, there's a search that's conducted by the patent office, you get the search report, and from that search report, you get an indication of whether there's patentability if you file it in the PCT. And that process is the beginning of you getting your patent. If you file in the US, you get a search, you get an office action, that's what it's called. You get the search results, and you get what the examiner thinks may be patentable or not patentable. Your lawyer argues back as to why it is patentable. If you come to agreement, then you get notice of allowance, your patent will issue, and then as your patent's issuing, you have other applications to the PCT system, and you can then have them examined in each country, and they'll get allowed. It's a process, but that's basically how it works. Questions?
Sorry, I know this is about the United States and China, but besides Tunisia, which is a member of PCT, are there any countries in Africa members of PCT? What about South Africa, Egypt, Kenya, Morocco? Do you have any idea, guys?
All members. So Morocco, Algeria, Saudi Arabia, Bahrain, Iran, I think Iran, most countries in the MENA are members of the PCT. So you can file there. But if you're working with a law firm in these countries, they don't file a lot of foreign patents, international standard patents. and that's where you get in trouble. So the reason why this is more of an international process is that you want to file on the international standard. And many of the law firms in these countries just don't have the experience. And the process here is to help build that. I mean, we would work with a Tunisian law firm to get the international standard filed here in Tunisia. So my recommendation in this whole process is that we file either in The Hague for international filing, designated the US, China, and Tunisia, and we can file it through Tunisia. But I think it's important that we also file in Tunisia, so Tunisia has patents as well. So it's I think part of what we've been discussing as the plan. But the big markets, the investors, are mostly outside the country. So you have to follow the international standards. Does that make sense to you? Okay. Next slide. Okay. What we talked about here is you file in your country, then there are regions. So EP is a region, and then you have the international system, the PCT, that connects your country to the world. And that's what the PCT does. It connects your country, if it's a member of the PCT, to the rest of the patent world. And through that process, you can obtain patents everywhere in the world. And we've reached the end of our presentation. I'm not sure how we did the time.
Yes, we reached the end of the presentation. I don't know if there are like other questions.
Anyone?
Yeah. If we want to file US, is there any offer from your lower company to Tunisian startup?
What was the question?
Is there any specific offer from you to Tunisian startup? No.
I'm not sure what that question is. What does that mean?
It means, in fact, you are looking to put a patent at US, and we need a lawyer here in Tunisia. We haven't specialists in PI and mainly how to put a patent at US. And the idea is we have to work with either you or another company of lawyer specialist in PI. So I'm asking you if you have an offer for Tunisian startup. This is my question.
Sure. I've worked with many Tunisian startups, and we'd be happy to talk to you, but that process is going to be done through the system.
Maybe to add something, Enis. So as part of Promise, the idea of our intervention is to do some sort of training and also ultimately support startups in the end-to-end process at international level. So it's a next step. So we will get back to you with updates regarding maybe the more concrete support for you and all the other startups that are here in case they need something. So this is a next step.
Okay, thank you.
So as I understand it, the system is being built to put in place where startups will be interviewed and selected for the next step of patenting and supporting them in their development. And this is the training session, and there'll be a selection process as to who they use. The pricing will be negotiated with the country. And as I understand it, those costs and fees will be covered. And there'll be a competition basically for the individual, as I understand it.
Thank you, Alfred. I just wanted to add that the third, at the beginning of the training, we presented like 4 modules. So the third one is more like an info session about the advantage of the Startup Act. So if you are all labeled, I think you are all labeled startups, so you all can apply for this advantage. And hopefully it will be operational, I mean, very soon. So once we do the info session, it will be implemented, and you can, at this time, you can, at that time, you can apply, I think, through the platform Startup at the end, but not now. Now it's not operational. So we will let you know once it's on.
If you have any questions, any questions?
Yeah, just sort of comment, no, not a question. We hope all of this will be on track as soon as possible. I mean, the process of getting labeled as a startup.
Yeah, so it's the next next step. So maybe I think in I don't know, in 1 month, we hope that we will do the info session about the process. What are the documents that you need to prepare to get the fees for and the assistance for the international patenting. And we are going to collaborate with an international law firm that will help you through the whole process. It will depend, of course, on the country that you will choose, and also about the file that you are going to, I mean, and about your application, because you will need to justify why these countries and if you are patentable.
Okay. Just
so just to add something on what Aisha says, we will be sending you a sort of evaluation form, and in the evaluation form there is a question where if you need any type of maybe assistance or if you're thinking about patenting, just fill it so that we understand your needs early on.
Okay, we hope for the sake of the ecosystem here, just we had at least one case of a software company. I know I get the lesson, but the patent should be crafted as a method or a process to pass through the patenting process. But for the whole startups here in Tunisia, I really hope that we had at least one case of a software startup that get through the process, and I mean the high standard of the process, like filing in the US or in Europe.
Thank you. Enis, did you want to ask a question? You're on mute.
I have one question to Alfred. In fact, I have already some patents at US and at Europe, and I'm used to work with PI law firms to write this patent. And in fact, they come to us. We write a short description, but when they come, in general, they look to our system, and the claims at the end are completely different what the researcher or CEO think about and what we have to write. Does it work also with you, or at US? It means lower firms come and see the invention and could change claims, or isn't a good way to do it in this?
Well, in the old days when we didn't have the virus, we would always meet with the inventors. A patent lawyer has to meet the inventors, has to do an inventor analysis, who inventors really are, what the device does, and gather all that information before you can even start to think of writing a patent application. So it's quite an involved process. You really need to know the people you're working with. So for example, for Vermeeg, I've worked with them for years, knowing their technology and their processes, and getting to know the individual people in the firms and the different groups, and really putting together a strategic plan of what to do. You need to know your client in order to serve them properly. So yes, so typically you would have to understand the invention, see how it goes, and you write a description of the invention that is broad enough to capture ideas and concepts of that invention you may not even quite realize. So it has to be a very broad approach to drafting, and it has to be in detail enough to support the claims that are issued by that patent. Did I answer your question?
Yeah, definitely. Yeah, thank you.
Okay. Anyone else? Well, I want to thank you all. If there's no more questions, I'd like to thank you very much for giving us this opportunity to present to you. And
Maybe Alfred, if we can collect some feedbacks from the 4 startups that are here, quickly.
Sure.
Maybe if you can write in the chat what your feedbacks about the training, and we'll collect them. Or if you have something to say.
It's very interesting. I want to thank you all for the presentation. It's too much info to digest. It's overwhelming. And the process is very long and very complex. Actually, we started some discussions about patenting in the UK, but I was not in charge. I'm not the one in charge with the topic. So I know it's very complex and very, I just want to thank you for this info. Looking forward for Startup Act and for Promise program for further aspects about the intellectual property, and that's it.
Thank you. Anyone else? Any other comments? I guess they want to know how well we did and if you thought it was useful. So make sure you tell them what your thoughts are, so we can.
Thank you, Alfred. It was a really great presentation. It's very clear, and also we got also an idea about how much average the cost of a patent is, which is not easy to say, especially the specifications around software patenting, what has been going on in Tunisia, and also hardware patenting in China, which many startups are asking about here, and that we're assisting. Thank you all for the clear presentation, and hope to meet you all in the second session. Thank you.
Look forward to it as well. Any other questions or comments? Ahmed, did you find this helpful to you? You're on mute.
Which Ahmed? Ahmed Moumi or me?
Any Ahmed who wants to speak.
Actually, the problem, what we wanted to know, it's about software, and now for real, guys, not because Aisha asked to ask us. Just for real, we get the entry point of that, and besides that, we know that for sure to make it broad and make it quick is to get a high standard writing of the application and put it on the right place, depending on our needs, on the market we need to go, and our strategy actually in the start. So thank you guys. We get personally, I get what I want.
Good. Aisha,
thank you, Alfred. Thank you, Patrick. Thank you, Sean, Richard, and me. It was really interesting and very complete.
Don't forget Matteo. Don't forget Matteo.
Oh, and Matteo. I'm sorry.
No worries, no worries. It's very nice.
I'm sorry. Désolé, Matteo. So next step is that we're gonna send a form for the startup and the participants, so we can gather their feedbacks, but also what other areas of assistance, maybe more detailed, maybe if they have specific needs, and also about we will keep in touch for the third session, and once we will let you know once the operation, once the process is operational. Voila. Thank you.
Thank you all. Take care.
I have one question maybe for the startups. So as you may have seen, we recorded the presentation. We just wanted to have your permission if we can, share it, or maybe, I don't know if you have any problem of sharing the presentation. Let us know, and we will send you the PDF presentation and also the recording to you. But if you have any problem with sharing to other people, let us know.
Thank you very much. Thank you all.
Thank you, everyone.
Take care.
Thank you. Bye-bye.
Thanks.
Bye.